Hi everyone, I am Jessica L. Nabual, the first presenter of Group 2, which I will be tackling about the Chapter 4, which is the malversation of public funds or property. So what are the crimes called malversation of public funds or property? Let us first define what is malversation. So malversation is misbehavior and especially corruption in an office, trust, or commission that is defined by the Merriam-Webster. So, what are the crimes called malversation of public funds or property? They are first, malversation by appropriating, misappropriating, or permitting any other person to take public funds or property according to Article 217. Failure of accountable officer to render accounts in Article 218. Failure of a responsible public officer to render accounts before leaving the country in Article 219. Illegal use of public funds or property in Article 220. And failure to make delivery of public funds or property in Article 221. So let's start in Article 217 of the Revised Penal Code, malversation of public funds or property. Presumption of malversation. Any public officer who, by reason of the duties of his office, is accountable for public funds or property, shall appropriate the same, or shall take or misappropriate, or shall consent, or through abandonment or negligence, shall permit any other person to take such public funds or property, wholly or partially, or shall otherwise be guilty of the misappropriation or malversation of such funds or property. In all cases, persons guilty of malversation shall also suffer the penalty of perpetual special disqualification and a fine equal to the amount of funds malversed or equal to the total value of the property embezzled. The failure of a public officer to have duly forthcoming any public funds or property with which he is chargeable, upon demand by any duly authorized officer, shall be prima facie evidence that he has put such missing funds or property to personal uses, as amended by Republic Act No. 1060. Ano nga ba yung embezzlement? Malversation is otherwise called embezzlement. Put the word embezzled in the phrase or equal to the total value of the property embezzled in the ultimate paragraph of Article 217. So, the elements common to all acts of malversation under Article 217 is A. That the offender be a public officer. So, kailangan yung offender natin is public officer, public employee, public servant, anyone who is working under the government. B. That he had custody or control of funds or property by the reason of his duty of his office. So, meron siyang control sa pondo o property na pagmamayari ng gobyerno. Ikatlo, or letter C, that those funds or property were public funds or property for which he was accountable. And letter D, that he appropriated, took, misappropriated, or consented, or through abandonment or negligence, permitted any another person to take them. So, one best example of malversation case is the case of People versus Longara and Cinco. So, yung si Bonifacio Longara is a traveling deputy in the Office of Provincial Treasurer of Samar. He received from the Office of the Provincial Treasurer the sum of 30,000 pesos in bills. Ang karawat yan kwartahin 30,000 pesos from the Provincial Treasurer nga gagamiton in connection para sa pagbayad para sa mga sweldo ng mga teachers sa municipality ng Giwan, Mercedes, Maydulong at Burungan. Ngayon, yung Provincial Treasurer verbally ordered Francisco Cinco, which is a mailing clerk lang siya ng Provincial Treasurer, disuguhihan Provincial Treasurer, verbally nga, escort hi Bonifacio Longara. Ngayon, iniising ko, gimpakilala hi Longara, hataw nga nagngangaran Henry Dan. Henry Dan, waray mag-alang, nagyakan Longara, nga, pwede nira, pikion, ang kwarta nga adaha iya. Yan na, hi Longara, nagdinay nga waray kwarta iya, but Cinco knew, nga may kwarta ha iya, nasa ring hising ko nga, that is good if you can entertain, then it is something. Obviously, reminding Longara of the government funds he had with him to pay the teacher. So, maarami singko may kwarta kan Longara, which is the 30,000 pesos, nga nayakan niya, okay na ito, kaya din naman ko na imo, nga, ang mga ibarayad na mga salary ng teacher. Longara nga ni Cinco, kumadto ha Tacloban City, nag-rent ha room ha Leyte Hotel, ngan Henry Dan, nagpakita hiya nga ito nga nasabi nga room, and then, Henry Dan borrowed the money bills nga gin-assure niya hi Longara nga ito nga mga kwarta, ito nga 30,000 from the Provincial Treasurer nga diri ito mawawara nga iyalay ito kukupyahon kuno. After such time, Henry Dan never showed up waray na magpakita nga naan mga kwarta waray na. Cinco, Cinco as a mailing clerk, di rin ko niya accountable public officer. Of course, mailing clerk, manlahiyahan provincial treasurer. Held when a private person induces a public officer. Ito na yung nangyari kay Longara. He was induced by Francisco Cinco, a mailing clerk, not a public officer, merely a private person. He induces a public officer, which is si Longara, or by necessary acts aid a public officer in consenting or permitting such public funds to fall into the hands of a swindler. So yung swindler dito, si Henry Dan. He must be held equally liable with such public officer for malversation. So si Cinco is equally liable with the of malversation na ikakaso kay Longara. For when the law clearly defines a crime as it has here defined the crime of malversation, those who in a way participate therein must be principals, accomplices, or abettors thereof. So, kung ano man yung ipapataw at naipataw na penalty kay Longara, ay ganun din ang ipapataw kay Cinco kahit na siya ay private person at hindi public officer, because sabi nga dito, if a private person ko induces a public officer, so siya yung nagpakilala, siya yung nag-induce sa public officer na gawin ito, gawin yan, tapos pinakilala niya pa sa swindler, and then yun na, nawala yung money, tas dalawa sila ay liable sa malversation case. So the next article we'll be tackling is Article 218, which is the failure of accountable officer to render accounts. Any public officer, whether in service or separated therefrom by resignation or any other cause, who is required by law or regulation to render accounts to the insular auditor, is now called Commission on Audit, or to a provincial auditor, and who fails to do so for a period of 2 months after such account should be rendered, shall be punished by a prisión correccional in its minimum period, or by a fine ranging from 200 to 6,000 pesos, or both. So, the elements of Article 218 of failure of accountable officer to render accounts. First is that the offender is a public officer, whether in service or separated therefrom. So, ibig sabihin, nasa serbisyo pa or nag-resign na. Kalawa, that he must be an accountable officer for public funds or property. Isa siyang accountable officer, responsible sa mga public funds or property ng gobyerno. That he is required by law or regulation to render accounts to the Commission on Audit or to provincial auditor. So, required daw siya ng batas o regulation na ibigay yung mga account na sa Commission on Audit or sa provincial auditor. Pang-apat, that he fails to do so for a period of 2 months after such account should be rendered. Pang-apat daw, he fails, nabigo siya na gawin yung naipasa o ibigay yung mga accounts by the period of 2 months. So, next one is the Article 220, which is the illegal use of public funds or property. Siguro, understandable naman yan, illegal na paggamit ng public funds or property. Any public officer who shall apply any public funds or property under his administration to any public use other than that for which such funds or property were appropriated by law or ordinance shall suffer the penalty of prisión correccional in its minimum period, or a fine ranging from 1/2 to the total value of the sum misapplied, if by reason of such misapplication any damage or embarrassment shall have resulted to the public service. In either case, the offender shall also suffer the penalty of temporary special disqualification. If no damage or embarrassment to the public service has resulted, the penalty shall be a fine from 5 to 50% of the sum of misapplied. So, yung element ng illegal use of public funds or property, first is that the offender is a public officer. Kailangan public officer siya. Pangalawa, that there is a public fund or property under his administration. Merong pera or possession or property na under sa kanyang administrasyon. Pangatlo, that such public fund or property has been appropriated by ordinance, o yung fund na yun o yung property na yun ay appropriated by law or ordinance. Dapat, that he applies same public than for which such fund or property has been appropriated by law or ordinance. So there is no technical malversation if there is no law or ordinance appropriating public funds or property for a particular purpose. This reminds me of Latin maxim, nolum crimen nolla pena sine lege, which means there is no crime if there is no law punishing it. The same is true na walang technical malversation kung wala daw batas or ordinansa na nagpapunish nito. The court has unequivocally ruled or clearly ruled in Parungaw or versus Sandigan Bayan, GR number 96025 in May 15, 1991, that in the absence of law or ordinance appropriating the public fund allegedly technically malversed, in that case, the absence of any law or ordinance appropriating in the CRBI fund for the concreting of Barangay Halong Road, the use thereof for another public purpose, there for the payment of wages of laborers working on projects other than the Barangay Halong Road, will not make the accused guilty of violation of Article 220 of the Revised Penal Code. So kung wala daw yung batas na Article 220, which is the illegal use of public funds, hindi naman magiging guilty yung isang tao na ginamit yung public funds sa maling pamamaraan. Kasi nga, nolam krimen, nola puena sa nilehe. This is applicable to all crimes. Kung walang batas na nagpaparusa sa isang krimen, hindi ito magiging isang krimen or hindi siya magiging punishable. So yung public funds or property must be appropriated by law or ordinance for a particular purpose. Example of illegal use of public funds. When the school teachers and other municipal officers were unable to receive their salaries because the treasurer applied the funds appropriated from the payment of the said salaries to another public use, there is detriment and hindrance of the public services, because this is the US versus Ejercito. So, yung example nito, yung mga teachers daw o yung ibang municipal officer na hindi naka-receive ng kanilang mga salary dahil yung treasurer ay in-apply yung fund, yung supposedly salary ng mga teachers at municipal officers ay ginamit sa ibang public use, ginamit sa ibang projects, kung sabihin natin, merong detriment or hindrance ng sa public service. Isa ito sa example ng illegal use of public funds. So, that would be all. I hope meron tayong natutunan. Thank you.
Good day everyone. I am here to report the article 223, 224, 235 of the Revised Penal Code. Article 223, conniving with or consenting to evasion. Any public officer who shall consent to the escape of the prisoner in his custody or charge shall be punished. Conniving is someone who is prone to scheming in a harmful way. For example, it is a person who is always scheming to take things that don't really belongs to him. By prison correctional and its medium and maximum periods and temporary special disqualification in its maximum period to perpetual special disqualification if the fugitive shall have been sentenced by final judgment to any penalty. The next one is by prison correctional in its maximum period and temporary special disqualification in case the fugitive shall not have been finally convicted by any held as a detention prisoner for any crime or violation of law or municipal ordinance. And here is the element. First is that the offender is a public officer. Second, that he is charged with the conveyance or custody of prisoner, either detention prisoner or prisoner by final judgment. Third, that such prisoner escaped from his custody. And the last one is that he was connivance with the prisoner in the latter's escape. Article 224, evasion through negligence. If the evasion of the prisoner shall have taken place through the negligence of the officer charged with the conveyance or custody of the escaping prisoner, said officer shall suffer the penalties of arresto mayor in its maximum period to prison correctional in its maximum period and temporary special disqualification. Evasion is defined as avoiding or escaping of a person or a thing. For example, evasion is hindi rin pagbabayad income taxes for 10 years. suffer the penalties of arresto mayor in its maximum period to prison correctional in its maximum period and temporary special disqualification. And here is the elements. First is that the offender is a public officer. B. That he is charged with the conveyance or custody of a prisoner, either detention, prisoner, or prisoner by final judgment. And the last one is that such prisoner escapes through his negligence. Article 235, Maltreatment of prisoners. The penalty of prison correctional in its medium period to prison mayor in its minimum period, in addition to his liability for the physical injuries or damage caused, shall be imposed upon any public officer or employee who shall overdo himself in the correction or handling of a prisoner or detention prisoner under his charge by the imposition of punishment not authorized by the regulations, or by inflicting such punishment in a cruel and humiliating manner. If the purpose of maltreatment is to exert a confession or to obtain some information from the prisoner, the offender shall be punished by the prison mayor in its minimum period. Second, temporary absolute disqualification, a fine not exceeding 6,000 pesos in addition to his liability for the physical injury or damage caused, as amended by Executive Order Number 62, November 7, 1986. And here is the element. First is that the offender is a public officer or employee. Second, that he has charge of a prisoner or detention prisoner, otherwise the crime is physical injuries. And third, that the maltreats his prisoner in either of the following manners: by avoiding himself in the correction or handling of a prisoner or detention prisoner under his charge, either by the imposition of punishment not authorized by the regulations, or by inflicting such punishment thus authorized in a cruel and humiliating manner, or by maltreating such prisoner to exert a confession or to obtain some information from the prisoner. And that's all. Thank you.
Article 246 Parricide. Any person shall kill his father, mother, or child, whether legitimate or illegitimate, any of his ascendants or descendants, or his spouse. Ito yung pagpatay ng iyong ama, or ng iyong ina, o ng iyong anak, lehitimo man or ilehitimo, ay maaari kang makasuhan ng parricide sa Article 246. Ascendants or descendants. Ascendants. Ito yung parents, grandparents, bawal yung tito at tita. Descendants. Ito yung apo or anak, bawal yung pamangkin. Spouse, bawal dito yung kapatid or pinsan. Dapat yung asawa. Isa penalty naman ng parricide. Nakalakay sa batas ang reclusion perpetua to death. Pero dahil sa Republic Act 9346, walang death ngayon. Pero maaari ka pa rin makulong ng reclusion perpetua pagkakakulong ng 20 years and 1 day to 40 years. Article 247. Death or physical injuries inflicted under the exceptional circumstances. Any legally married person who, having surpassed his spouse, an act of committing sexual intercourse with other person, shall kill any of them or both of them, an act of immediately thereafter, or shall inflict upon them a serious physical injury, shall be suffer the penalty of gestiero. Maaari ka bang makulong sa Article 247? Hindi. Dahil kahit sinong asawa na nansorpresa na nagkikipagtalik ang kanyang asawa sa ibang tao o malubhan niya itong nasugatan o napatay ang kanyang asawa at ang kanyang kabit, ay maaari lamang siya makasuhan ng gestiero. Sa gestiero ay walang kulong ang akusado, pero bawal siyang pumunta sa lugar ng insidente. Ito ay hindi parusa, kundi protection niya laban sa kamag-anak na gustong maghigante sa mga nangangaliwang asawa o kabit. Article 248, Murder. Any person who not falling within the provision of Article 246 shall kill another shall be guilty of murder. Elements of murder: that the person was killed, that the accused killed him, that the killing was attended any of qualifying circumstances mentioned on Article 248. The killing is not parricide or infanticide. Merong 6 na qualifying circumstances dito sa murder. Pero magdi-discuss lamang ako ng isa. Ito yung treachery. Bakit ang pagpatay by means of treachery ay murder? Ano nga ba itong treachery? Ang treachery ay walang tsansa ang biktima na may pagtanggol ang sarili niya. Sample, sinaksak mo patalikod yung biktima or binaril mo. Yung sudden attack, nag-uusap lang kayo ng biktima, hindi nga siya nakatalikod, pero bigla mo na lang siyang sinaksak or binaril, pasok yun sa murder. Ang penalty ng murder na nakalagay sa batas ay reclusion perpetua to death. Pero dahil sa Republic Act 9346, walang death sa ngayon. At makukulong ka pa rin ng reclusion perpetua at pagkakakulong ng 20 years and 1 day hanggang 40 years. Article 249, Homicide. Any person who not falling within the provision of Article 246 shall be kill another without attendance of any circumstances enumerated in the next preceding article shall be deemed guilty of homicide. Okay. Paano malalaman kung ang pagpatay ay homicide ng Article 249? Kung hindi ascendants or descendants or spouse or wala sa justifying circumstances ng Article 248 ang nagawa mong krimen ay homicide. May intention ka man o wala. Sa penalty naman ng homicide ay reclusion temporal at maaari kang makulong ng 12 years and 1 day to 20 years.
Article 252. Physical injuries inflicted in a tumultuous affray. When a tumultuous affray, as referred to in the preceding article, only serious physical injuries are inflicted upon the participants thereof, and the person responsible thereof cannot be identified. All those who appear to have used violence upon the person of the offended party shall suffer the penalty next lower in degree than that provided for the physical injuries so inflicted. Malaki ang naging pinsala ang nangyari sa Pilipinas nang magkaroon ng digmaan. Halos lahat ng kabahayan ay nasira at nagkawasak-wasak. Dahil din dito, namatay ang mga pamilyang masaya na namumuhay sa kani-kanilang tirahan. Pati mga bata ay walang awa nilang pinatay, mga wala silang puso, nang dahil sa yaman ay nagkaganyan sila, nang dahil sa ginto at pilak, pumatay sila ng taong walang kalaban-laban. When the physical injuries are inflicted are of a less serious nature and the person responsible thereof cannot be identified. All those who appear to have used any violence upon the person of the offended party shall be punished by arresto mayor from 5 to 15 days. Or any insane person has committed an act when the law defines as a felony or delito, the court shall order his confinement in one of the hospitals or asylums established for persons thus affected, which he shall not be permitted to leave without first obtaining the permission of the same court. Article 253. Giving assistance to suicide. Any person who shall assist another to commit suicide shall suffer the penalty of prison mayor if such persons leads his assistance to another to extent of doing the killing himself. He shall suffer the penalty of reclusion temporal. However, if the suicide is not consummated, the penalty or arresto mayor in its medium and maximum periods shall be imposed. So, tips to prevent suicide. Don't discount their feelings. While you may think that their problems aren't serious enough to warrant suicidal thoughts or behaviors, what really matters is how serious they perceive them to be. If it feels important to them, then in their mind, suicide may seem like a valid option. Most importantly, never dismiss suicidal talk or threats. If a person is making comments that seem to indicate that they are depressed or thinking of taking their own life, you should always take them seriously. Look at suicide as a cry for help. When a person attempts suicide, this isn't necessarily a sign that they want to die. Instead, it's an indicator that they are in great emotional pain, but don't know how to deal with it.
Article 254. Discharge of firearm. Any person who shall shoot at another with any firearm shall suffer the penalty of prison provisional in its maximum and medium periods, unless the facts of the case are such that the act can be held to constitute first-stated or attempted parricide, murder, homicide, or any other crime for which a higher penalty is prescribed by any of the articles of the crime could any other crime for which higher penalty is prescribed by any of this article of this code. Sino mang gumamit ng baril o maril pa gamit ang anumang baril ay may mapaparusahan sa prison correctional sa pinakamababang panahon nito. Maliban kung mga serious na kaso o mga sugadan parricide o homicide o anuman nagkukuanhan iba pa nga krimen. Nare-refer ni hera o yung kakadtuha sa sakaha ibang article kunhain mas itaas kunhain may taas ng kaso para hair. Article 255. Infanticide. The penalty provided for parricide in Article 246 for murder in Article 248 shall be imposed upon any person who shall kill any child less than 3 days age. Kung hino man ang magpatay baby o sanggol na napapatawan hirahin di Article 248 amang gin papataw habisan hinuman nga tao nang pumatay hininaan na bata para ya hatulan in kakasunihin infanticide.
So, Article 256, killing of the fetus in the uterus or the violent expulsion of the fetus from the material womb which result in the death of the fetus. So, for example, Herebika, buro diya, pero waray pa hiya, naisip niya waray pa hiya financial na igkukanan iya, dari pa hiya ridi. Waray pa hiya igagastos, iya magiging anak. So, niya ginbuhat, nagtake hiya drugs or mga beverages nagkon hiya para malaglag niya baby. So, siya itong tinatawag nato na intentional abortion. Article 257, unintentional abortion. Imposed upon any person who shall cause an abortion by violence but unintentionally. So, for example, Jovi Bordia, nag-iinuran, gumawa siya. So, niya kay madalo na titang kalsada. Pag agi niya nga diha may kuan, nabalindas siya. So, pagkabalindas niya, dida niya nakunan. So, siya ito na unintentional, diri mo sinasadya nga mapunit sanggol hai mo.
Article 262, mutilation. The penalty or reclusion temporal to reclusion perpetua shall be imposed upon any person who shall intentionally mutilate another by depriving him, either totally or partially, of some essential organ for reproduction. The term of mutilation means the lopping or crimping of some part of the body. The two elements of mutilation. First, that there be a construction that is mutilation or organs necessary for generation, such as the penis or ovarium. The common mistake is the associated this with the reproductive organs only. Mutilation includes any part of the human body that is not susceptible to grow again. If was cut off was a reproductive organ, the penalty is much higher than that for homicide. Under the revised penal code, the penalty imposed for the crime of homicide, it is reclusion temporal with a duration 12 years and 1 day to 20 years prison. This cannot be committed through criminal negligence. And second, that the mutilation is caused purposely and deliberately, that is the deprive the offended party of some essential organ for reproduction. The intent to deliberately cut off the particular part of the body that was removed from the offended party must be established. If there is not intent to deprive victim of a particular part of the body, the crime is tinatawag natin na serious physical injury or murder. It is reclusion perpetua, fine ranging from 500,000 pesos. That is the Article 262 mutilation. Article 263, serious physical injuries. Any person who shall wound, beat, or assault another shall be guilty of the crime of serious physical injuries and shall suffer the First, the penalty of prison mayor if in consequence of the physical injuries inflicted, the injured person shall become insane, imbecile, impotent, or blind. Second, the penalty of prison correctional, it is medium and maximum periods if in consequence of the physical injuries inflicted, the person injured shall have lost the use of speech or the power to hear or to smell, of shall have lost an eye, a hand, a foot, and arm, or a leg, or shall have lost the use of only such member, of shall have become incapacitated for the work in which he was therefore habitually engaged. Third, the penalty of prison correction in its minimum and medium periods if in consequence of the physical injuries inflicted, the person injured shall have become deformed or shall have lost any other part of his body, or shall have lost the use thereof, or shall have been ill or incapacitated for the performance of the work in which he is habitually engaged for a period of more than 90 days. Fourth, the penalty of arresto mayor in its maximum period of prison correctional in its minimum period if the physical injuries inflicted shall have caused the illness or incapacity for labor of the injured person for more than 30 days. If the offense shall have been committed against any of the person enumerated in Article 2 or 6, parricide, or with attendance of any of the circumstances mentioned in Article 248, murder, the case covered by the subdivision number 1 of the article shall be punished by reclusion temporal in its medium and maximum periods. The case covered by the subdivision number 2 of prison correctional in its maximum period to prison mayor in its medium it is its minimum period. The case covered by the subdivision number 3 by prison correctional its medium and maximum periods, and the case covered by subdivision number 4 by prison correctional in its minimum and medium periods.
Article 265. Less serious physical injuries. Any person shall inflict upon another physical injuries not described in the preceding articles, but which shall incapacitate the offended party for 10 days or more, or shall require medical attendance for the same period, shall be guilty of less serious physical injuries and shall suffer the penalty of arresto mayor. Take note, sa krimen, ang tao ay gumawa ng ibang physical injury sa ibang tao at ang pinsala nito ay hindi makatrabaho ng more than 10 days at less than 30 days, o kaya may medical assistance for more than 10 days at less than 30 days. So, ayon sa batas, kapag walang time period o permanenteng hindi makatrabaho ang isang tao dahil sa injury na natamo, ito ay serious physical injuries. Kapag more than 30 days hindi makatrabaho or more than 30 days medical assistance, ito ay serious physical injuries under sa paragraph 4 of Article 263. At kapag less than 10 days naman, ito ay slight physical injuries. The penalty of less serious physical injuries is arresto mayor o pagkakulong ng 1 month, 1 day to 6 months. Whenever less serious physical injuries shall have been inflicted with the manifest intent to insult or offend the injured person or under circumstances adding ignominy to the offense. In addition to the penalty of arresto mayor, a fine not exceeding 500 pesos shall be imposed. Any less serious physical injuries inflicted upon the offender parents, ascendants, guardians, curators, teachers, or persons of rank, or persons in authority shall be punished by prison correctional in its minimum and medium periods, provided that in the case of persons in authority, the deed does not constitute a crime of assault upon such persons. Kapag ang less serious physical injury ay may kasamang panginsulto o saktan ang damdamin ng biktima, ang krimen ay qualified less serious physical injury. At ang penalty nito ay aresto mayor na may kasamang fine na hindi lalagpas sa 50,000 pesos. At kapag ang less serious physical injury ay may kasamang ignominy, ito ay may penalty na aresto mayor. Ito ay may fine na hindi makalagpas sa 50,000 pesos. Take note, kapag walang less serious physical injury at ang ginawa lamang ng salarin ay insultuin o saktan ang damdamin ng biktima, ang krimen ay slander by deed. Kapag ang biktima ay magulang, ascendants, guardian, ito ay qualified less serious physical injury at may kaparusahang prison correctional and its minimum and medium period. Article 266, slight physical injuries and maltreatment. So, ang physical injury ay maaaring mangyari kapag may wounding, beating, assaulting, at ang slight physical injury naman ay ang pinakamababa sa lahat. 3 acts that slight physical injuries can be committed. Una, by arresto mayor, when the offender has inflicted physical injuries which shall incapacitate the offended party for labor from 1 to 9 days or shall require medical attendance during the same period. Pangalawa, by arresto minor or a fine not exceeding 40,000 pesos and censure when the offender has caused physical injuries which do not prevent the offended party from engaging in his habitual work, require nor medical assistance. Pangatlo, by arresto minor in its minimum period or fine not exceeding 5,000 pesos when the offender shall ill-treat another by death without causing any injury. So, sa paragraph 1, dapat may injury at ang nasabing injury ay nagresulta ng incapacitated for labor from 1 to 9 days or shall require medical attendance during the same period. Take note, dapat ang injury na mo ay 1 to 9 days. Ayon sa batas, ang penalty sa paragraph 1 ay physical injury by arresto mayor o pagkakulong ng 1 month and 1 day to 6 months. Sa paragraph 2 naman, may physical injury pero hindi ito nagresulta o pinagkaitan ang biktima na makagtrabaho at wala din itong medical attendance. Halimbawa nito ay confusion sa muka o black eye. Pero kapag may deformity na nangyari, disregard na ang healthy duration or medical treatment dahil kapag may deformity, ito ay serious physical injury. Kahit na ang deformity ay hindi nagresulta o incapacitated for labor at kahit ang medical attendance ay hindi higit ng 9 days, isa pa rin itong serious physical injury. Ang deformity ay nagresulta ng physical ugliness, permanent or definite abnormality, conspicuous and visible. Ang penalty sa paragraph 2, Article 266 ay arresto minor o pagkakulong ng 1 day to 1 month or a fine not exceeding for 40,000 pesos. Sa paragraph 3 naman, when the offender shall ill-treat another by death without causing any injury, Sa paragraph 3, walang injury na nangyari at walang hospitalization at walang incapacitated for labor. Ang halimbawa nito ay slapping without causing dishonor. If slapping the face with causing dishonor, the crime might slander by death or less serious physical injuries. Ang penalty sa paragraph 3 ay arresto minor. In its minimum period ay a fine not exceeding 5,000 pesos.